where people practice, disputes occur almost every day. This is so because construction itself is inherently difficult. With the inherent difficulties of construction, it is all occurring within the context where people are wanting to make money. This introduces an inherent tension. It is always important that the tension is creative in the sense that the professional team, the agents, the professional agents are supposed to hold the client and the contractor accountable to one another. The client issues instructions, the client agrees to designs and drawings, but there is always a tendency for clients to want thinking after the fact that they might be wanting to alter their wants or their needs or their expectations. This can happen simply because of the change of mind. It also happens because circumstances do change. It happens quite often that a client is intending to build a structure that is intended for purpose A, but then there is a change in the marketplace and there are new demands, and the client wants to quickly cover those new demands within the same budget. This introduces tension. I'm just mentioning one example of tension. Equally, on the other hand, contractors might have priced January last year and there is a delay in the award and the award comes December. But because there is scarcity of work or just out of sheer optimism, one thinks they might be able to get away with the project within the historic price. That on its own will ultimately lead into circumstances where one is shopping for cheaper prices, for cheaper materials, for cheaper labor, for alternative replacements. This too introduces tension. Some of you are going to end up on the contractor side. Some of you are going to end up on the client side. Some of you are going to end up with professional agents in the middle side. And some of you will be crisscrossing all these roles in the different phases of your career in life. But what is more important is that in all of this, tension is inherent and disputes do occur, much as they may be avoidable, but they do occur. The module that then deals with dispute resolutions is very important in all the life you're going to be living. Now, for a start, you will note that your notes are quite thorough with regards to the dispute resolutions. Later on, or when you come across this in the library, do pick up FinCEN's The Building Contract, a commentary on the JPCC agreements. It's a book by Juta and Company. Most of the notes are aligned to this textbook. The textbook and the slides do discuss the increase in incidents of disputes. This is but one of what I've just highlighted to you. Right now, there is COVID all over the country. You can imagine how much havoc this is wreaking within the construction industry. If there is a stoppage on a site because of COVID, it means somebody has to pick up the bill for the security of the site, for the labor escalation, for the escalation in the cost of materials, whether this is the client or the contractor. But somebody has got to pick up the cost that's associated with COVID-related delays. In certain cases, contractors have actually tried to terminate on the basis of what is normally called force majeure. Sometimes it's called vis major. It's one and the same thing. It's simply a statement which says it's impossible to work or to perform under the contract. Now, this has happened in the Mthendu Bridge. There is a massive project that's happening on the N2 between Port St. John's on the construction of a site that's going to the road going to Port St. John's, Port Edward, all going to the Natal. but that happened on a different set of reasons. Numerous other construction contracts are stopped because of COVID, and some contractors have filed for vis major, which is simply saying it's impossible to perform under the contract and therefore I don't want to be held liable. That on its own is dispute. On contracts where there is no cancellation, when you had priced for a bag of cement and you could have performed the work in January last year, now a bag of cement was 90 rands then, and today a bag of cement is 120. Someone has to pick the cost. It may be the contractor if the client is refusing. It may be the client if the contractor is well capable of presenting his case. That on its own is an incidence that will introduce a possibility of a dispute in the administration of contracts. We may move to the next slide. That will be probably slide 3 or 22.2. What happens then when there are disputes in the construction industry or in the administration of construction contracts? Now, most standard engineering contracts make provision for resolution of dispute by way of arbitration. All of these are belonging in a category of dispute resolution mechanisms that are generally summarized as ADR, which means alternative dispute resolution. Now, within the alternative dispute resolution, there are a range of options. But if it is alternative, what is it an alternative to? It is alternative to litigation. It is alternative to resort to courts. Now, within the ADR, alternative dispute resolution methods, you have mediation, you have conciliation, you have arbitration. They are all given different names, but the essence of them is to quickly deal, one, with inherent tensions that are introduced by competing interests in between the three parties that are involved in the construction industry. Because all of these are pursuing profit. And in the center is a professional agent who also wants his project or the project that he is monitoring to be delivered promptly in the same quality specification within the agreed time, so that the professional agent can also live with a better reputation. So there is generally an inherent tension in these interests, but which can be managed. Now, the alternative dispute resolution mechanisms, including arbitration, which we are about today, leave the power to determine when a resolution of dispute can occur to the parties that are in the contract. Why am I saying so? When you are resorting to a court, there you have a different set of people that are running the show. You must go and roll your case with the registrar. It joins a very long roll. Some cases that are on the same roll are for a different set of cases. There are rape cases, there are murder cases, there are fraud cases, there are other disputes that are of a civil nature that are already at court. And all of those are to be dealt with by a limited number of judges. It happens quite often that you will find, as a way of example, Mthatha High Court has got about 8 permanent judges. Port Elizabeth High Court has got about 14 or 15, I'm not sure what the number is. Some of them are going to take leave from time to time. Some of them are allocated in very long cases that take 5 days to be heard and have got a range of competing responsibilities that they must deal with in order to discharge their functions at court. Now, when you take your dispute there, it is very easy that it will be at the bottom of the list because you came last. It might be postponed because the judge is sick. Now, if you take this to arbitration between the parties that are in dispute who want this resolved, they are able to have an arbitrator appointed, and that's going to be an independent person. And the arbitrator so appointed is responsible primarily to focus on the case that is being given by the parties who are in a dispute for purposes of arbitration. This then makes arbitration quite expeditious. It makes arbitration leave the power to expedite the resolution of dispute within the parties that are in the agreement. Now, if they want it heard within 2 weeks, they can actually speak to the arbitrator to hear the matter within 2 weeks, and the arbitrator will put the time aside. So, and the other problem with civil litigation is that it is highly acrimonious. Parties in court end up completely not talking to one another. This has the risk of damaging the relations, including for future. Whereas in arbitration, there is less acrimony. Now, we have to discuss the nature of arbitration, what arbitration actually is. I'll take you to 22.4 on the slides so that we go together. That's point 4. Let me read verbatim on this one. Arbitration is a procedure freely and voluntarily adopted by parties. They agree to submit any dispute to impartial judgment of third party of their choice instead of courts. That's what arbitration is. In practice, how does this happen? As I've said earlier, all engineering contracts. In engineering, in construction, we use standard contracts. For building, you have JPCC. For civil engineering works, you have general conditions of contract for civil engineering works. These two contracts, the JPCC and the GCC, are generally used in domestic projects. In other words, in projects that are understood to be attracting only contractors within South Africa. If you are building a hall in Port Elizabeth, a bridge in Uitenhage, and the bridge is generally within the capacity of the South African construction industry, it is expected that the contractors who will be working in that bridge will be mainly placed in South Africa. Then what the professional team selects is one of these domestic standard contracts, which is the JPCC and GCC. I say they are domestic because they originate primarily here, and the committees that review them are based here in South Africa. They are also more aligned to the design standards of South Africa, like the GCC, which is for civil engineering works, is mainly based on COLTO, which is a document that's developed by the Committee of Transport for States, Roads and Bridges. That committee is based at the Department of Transport here in South Africa. So that's one that designs COLTO as a standard on how public infrastructure must be constructed in the civil space. And when GCC is produced, the standard contract itself, it uses COLTO terminology, it uses COLTO philosophy. Now, what happens when South Africa is wanting to build a stadium, and the assessment is that this might attract international players? Then the normal document that would be selected as a standard contract will now be FIDIG or any other international version, but primarily it's FIDIG, which is based in France, to the extent that I may remember, the committee that actually reviews it. This is so because it's expected that there might be a company from Germany bidding, a company from Britain bidding, a company from France, or a conglomeration of companies from different territories. So it's understood that once companies grow in stature, mature in size, and become international players, the project leaders of those companies will be well versed, including on the international versions of the engineering of the construction contracts. So for your purposes, for start, it will help you to be quite well versed with the JPCC in the context of the building sector. But it will not harm you again, to be well versed in the GCC, because some of the contracts that you're going to be involved with will have an interplay of massive civil works together with massive building works. Now, all of these contracts, local versions, the so-called domestic and international versions, have provisions for dispute resolution mechanisms. Later on, we shall deal with the procedure precisely to be followed in referring a matter to a dispute resolution. Now, what normally happens in practice, because parties are now in disagreement, there is a degree of mistrust. A contractor will not agree to the employer simply selecting an arbitrator on his own. Generally, the professional assistant, the quantity surveyor, the civil engineer, who is a neutral party, might select an arbitrator. And the advantage is that when an arbitrator is selected, it will be the parties will be selecting somebody who's going to be well versed in the construction space. If not, the parties may agree that a person who is going to be selected will be chosen by the chairperson of the Society of Advocates in that particular division. In Port Elizabeth, there is a Society of Advocates. In Bishop, there is a Society of Advocates. Wherever there is a High Court, there is a Society of Advocates. In the majority of cases, people prescribe that a person will be selected from the Association of Arbitrators South Africa. It's a non-profit organization. I'm a member of that institution. When parties are in disagreement, they might write to the chairperson of that institution to say, please assign us an arbitrator. The Association of Arbitrators, as a way of example, has special courses in construction engineering, in construction contracts, which actually helps so that a person who might be selected is well versed with the terminology that applies. Someone might not know what a payment certificate is, but a person who is well versed in the construction space knows what a payment certificate is. There is a law of general application in South Africa, which is Arbitration Act of 1965. It governs how arbitration proceedings must be held. Now, let's go to the next slide, which is 22.6. An arbitration agreement is always embedded in the standard engineering contract, as I've indicated. Now, when an arbitration is held, there are procedures to be followed, and there are standards which bind an arbitrator. An arbitrator must not be conflicted. A conflict arises where one has an interest in the outcome. Way of example, if you are a director of a company that is building a mall, you have shares in that company, but in your other life, you are a practicing advocate. You cannot take a brief to arbitrate a dispute that involves the construction of your own mall. So if you do that, that would amount to misconduct. One, you will lose credibility. Two, the perception of fairness, the perception that you are neutral, the perception that your judgment is based on well-reasoned views will evaporate, and the parties to a dispute are likely to disagree with your finding. And there are mechanisms available in law which allow, in terms of the Arbitration Act, for parties to take the actual arbitration award to court for a review. The whole point about it is that an arbitrator has to conform to rules of natural justice. He may not be a personal beneficiary of the outcome and has to hear parties at the same time. The minute you are starting to be meeting people privately when you're an arbitrator, a perception that you are unfair and you are biased might be founded. What is this thing of natural justice? Or natural justice is an old doctrine. It's as old as the hills. It's founded from Rome. It's if you are to hear a case, each of the two people must be given a chance to prepare. Each of the two people must be given a neutral platform, and each of the two people are entitled to a reasoned decision. Now, once an award has been given, in terms of the Arbitration Act, a party who has won on the arbitration can make the arbitration award an order of court. Why is this important? Imagine for a second, you are a contractor and a decision has come from arbitration that you must be paid 2.5 million. On your own, you're not gonna go and pull the money out of the employer, the building owner, or in the case of a public of organs of state, from the municipality or a department. Though you have this award, but you can't enforce it because on your own, though you have won on the arbitration, on your own, you're not going to be able to enforce it. The arbitration allows you to take that arbitration award on application to court for it to be made an order of court. Once it's made an order of court, then you have real victory because the resources of the state can be mobilized to enforce your judgment. The sheriff can move. If the person is not paying, the sheriff can actually attach goods and sell them on public auction and then cause the money realized from public sale to be paid over to you. Then that way, the arbitration award becomes meaningful. Now, I must emphasize this point. An arbitration is a privately held dispute resolution mechanism. In other words, we choose who becomes the judge in our case. Even if we don't do so personally, we might say, Port Elizabeth Society of Advocates, president of that society, please give us a competent advocate who can hear our case. Once that is done, it can be expeditious, unlike when it goes through a long court process which we cannot control. Now, let's move to 22.7 and discuss the concept of mediation. Let's understand how a dispute arises. As having been discussed earlier, once we know we have a disagreement, at first we might try to speak about it and disagree. Second, from there, we might try to engage in an informal mechanism to call person X to say we have this challenge. Then when that doesn't work, we go to arbitration, which is more formal. A mediation is equally a voluntary process, but it's less formal than arbitration. It is similar to arbitration in many respects, but the problem with mediation is that it is less formal. Even if there is a decision from mediation, no provision is made in law for it to be made an order of court. So a mediation is a less formal version of arbitration. In practice, this thing is generally less useful when people are in serious disagreement. Let's move to 22.8, valuation and certification. The slide tells us here the parties also agreed to resolve their disputes by referring to a neutral person. I'm not going to refer any further to the slides on this point, but what is this in practice? In the construction space, you have a quantity surveyor for building, or you have an engineer for civil engineering works. A quantity surveyor is appointed by the employer. He or she is the one who assesses the quantity of work done, and he or she is the one who approves the work. He or she is the one who makes a payment certificate. In the academic sense, this person is the valuer who performs the certification of work. These are two functions. Valuation refers to the assessment of the quantities of work and the value of work to be done, to be paid for. Certification, on the other hand, deals with a separate aspect. Certification deals with this determination of whether the work is done satisfactorily or not. In the context of the building, it is the quantity surveyor, or as it is sometimes called, the principal agent, who assesses if the quality of plaster is correctly done and determines that no, this plaster must be redone. I am not happy with it. It is this quantity surveyor or the principal agent who assesses whether the paintwork is appropriate or whether the paintwork is not appropriate. That is the component that deals with certification. This certification determines whether the work is done in a satisfactory manner, in the quality that is expected. And when this certification has been done, the decision is final. It's not for the client to come back and reject work that has been approved by the principal agent or the quantity surveyor. That's the certification component. The valuation component deals with the estimation of how much money must be paid. These are two important functions that whenever you will be living your lives as principal agents or quantity surveyors who are responsible for certifying payments, you must take very seriously. In the case of our law here in South Africa, it is accepted that whoever is identified in a professional capacity to be the assessor of works has a final decision with regards to that. This is long established. There has been numerous cases. There's been a case between Pulpach Municipality and Waveren Construction. That's an old case. It's a reported decision from 1966, which says the decision of the civil engineer or of the principal agent or the quantity surveyor responsible for works is final, and they are allowed to apply their own standards. Otherwise, let's really think about it at a practical level. There would be madness if person A walks in and says, this paintwork is done, it's proper, it's final, you can go. And person B comes back, says to the contractor, that man was talking nonsense, go back and do the work. And by that time, contractor is demobilized, has taken away everything, is gone offsite. Now that's the certification component. Equally, there would be absolute madness if the quantity surveyor or the principal agent or the civil engineer in the context of civil works has actually issued a payment certificate, but the employer, who is probably a doctor, who is having a building being constructed, simply says, nonsense, go to hell, I'm not going to pay on this thing. Yet they cannot know how to quantify works, but they are rejecting what has been determined by a professional in that space. There would be chaos. So equally, our law is plain. The payment certificate that's issued by an engineer or the principal agent or the quantity surveyor, as the case may be, is final, is a liquid document that has long been established since the cases of Smith versus Mouton. It's a 1977 decision. It's an old principle, including in English law, but it's the case including in our South African law. When a contractor has a payment certificate that has been signed by an engineer or a principal agent in his hand, it's as good as if he has a check. You will probably, not all of you will know about checks, because Now, people are using electronic transfers, and in fact, anyone who's still giving you a check these days is probably a crook, because now why is he not simply transferring the money? But in the olden days, we were paid with checks, and when you're presenting a check to the bank, you deserve nothing short of payment. Including now, when you're carrying a liquid document, it's an undertaking. So take your responsibility of signing payment certificates very seriously, because otherwise, if you sign them carelessly, you will be binding clients into very tricky situations that they cannot quickly move out from. Let's move to 22.9, scope of dispute resolution provisions in the JPCC agreements. This is nothing more than what we have discussed about. Save one point. In all the contracts, where, as I've indicated, all the standard engineering contracts, building contracts, have a provision for dispute resolution. Now, what happens when the contract is cancelled? One will want to say, if the contract is cancelled, then nothing can be taken from the contract. But in all these engineering contracts, there is a standing clause which says dispute resolution will remain valid even if the contract has been cancelled. And that actually makes sense, because otherwise there can be a valid cancellation of a contract. But now, by then, a contractor has constructed the building halfway. He has been paid only for foundations. Then work must still be quantified to determine how much is due to the contractor, and or what must be correct on the foundation that was already paid for. Now, even when the contract itself has been cancelled, there must be some mechanism to deal with this inherent tension, which is at the tail end of closing the file. This is why now it is said the dispute resolution clause survives the cancellation of contract. This is not automatic. This is so because in the writing of those agreements, they say so themselves. Now, if you get into any building contract and you don't use the standard contracts, and you're wanting to draft it yourself, which I don't know why you would want to do that, you must make sure if you are including a dispute resolution clause, you make it to survive the cancellation of contract. It's not automatic. If it was not worded the way it is worded in the GCC, in the JPCC, in FIDIC, this would not be the case. But Finsey in his books is writing based on the discussion of the JPCC. This is why he says, the authors here are saying, the clause survives the cancellation of contract. There is another aspect. Arbitration is not there for people to go and ask an opinion. You don't go to arbitration because you are thinking, is it whether right to do it this way or that way? No. The scope of arbitration is to resolve a disagreement, a dispute. There must first be a real dispute before there can be a referral to arbitration. This is a complex issue, the aspect where it is said there must be a real disagreement. And it is complex because if a payment certificate has been issued, but the employer is not paying, he is not disputing the payment certificate. He's not saying the payment certificate is issued wrongly. That's not a dispute, because there is no disagreement about the validity of the payment certificate. But there has to be a dispute. Once a payment certificate is due, and the contractor is not paid beyond the prescribed periods of 30 days, only then it might become a dispute if the contractor lodges a dispute. But the whole point about this, there must be a real conflict. It is to avoid using arbitration to seek legal opinions. Let's move to 22.10. I said we shall deal later with the initiation of proceedings. Here we shall be looking at the procedure stipulated in the JBCC. The procedure set out in the JBCC to resolve disputes removes the right from the principal agent to make decisions with regards to the matter in dispute, and instead empowers a neutral third party. Now, a dispute would have happened because someone is not happy at all. There can be a case where a contractor is directed to recommence with works and he feels there is some mistake in that decision. There may be a situation where the owner of the property, the so-called employer or client, feels the structure is not what it ought to be. There may be a dispute because no one knew there is clay. All the teams that are working the price because they thought they were gonna simply dig 15 centimeters and remove all soil and then find stable soil, only to find you must go down 2 meters to remove clay, and then you must import suitable material that much as well. That will lead into a problem even if it is paid for. How much additional time must be granted to the contractor? Remember, with time adjustment comes cost, preliminaries, and generals. Even if the client is not paying for cost, still the contractor must pay for supervision for longer than he had initially planned for. So the substratum, with time adjustment comes cost, because time is money. In the practical sense, you are in a project for 6 months, you've rented site offices, you've rented camps for your staff, now you must do this thing over 8 months. Someone has to pick the bill for the additional 2 months. So that too might lead into a dispute. But the point is, if the principal agent rules that there must be an extension of time for 2 months, there are instances where the client might not want to pay for additional 2 months. He may say, I'm willing to accommodate the additional 2 months. I won't charge penalties in that 2 months, but I'm not paying any additional cost for that. Then the blame game starts. Inherent conflict because of competing interests, each one wanting to make money for himself. So that then becomes a dispute. So when a dispute is to be launched, there are formal steps that are required to be taken to start the dispute resolution mechanism. It may be a disagreement, but once it escalates beyond that level, then it becomes a dispute. In the building agreements, a disagreement becomes a dispute when the principal agent's determination of the agreement is rejected by either party, or when the professional agent fails to give determination within the stipulated time. I've given you an example of when a rejection might happen. Somebody might feel, yes, I am the owner of the property. You were supposed to finish it in 6 months. We had agreed that if there is a delay, you will be paying penalties, but I can waive the penalty, but I'm not paying for additional supervision. A problem is started. Hence I was saying, disputes are inherent in the work you're going to be getting into. Whether you be the contractors, you stand for employers, you become employers, you become property developers, you become property owners, you work for the government as agents at the Department of Public Works or Department of Education, Department of Health, there is an inherent tension that you're going to be walking into, because everyone is wanting to make a profit. If you're standing on the side of government, you don't want your projects to run over budget. You don't want your project to run beyond the prescribed time frames, nor do you want your quality dimensions to be compromised. So there is generally an inherent tension. Let's move to 22.11, declaring a dispute. When a disagreement arises out of the building agreement, the principal agent must, on written request of the contractor, give a written determination of the disagreement within 10 days in writing to both parties. What you see here is a rehearsal of the provisions of the JBCC. The JBCC is being discussed because it's one of the most used versions in the building space here in South Africa as a domestic standard agreement. So when the determination has been made by the principal agent, this takes us into another aspect, the role of the principal agent. The principal agent sometimes works as what they call a quasi-arbitrator. What is that? A principal agent also works as an agent of the employer. What is that? When a principal agent is working as an agent of the employer, it is when he is issuing drawings, because those drawings have been approved by the employer, issuing site instructions on how the work must be carried out. In that role, though the PA is neutral, he or she is working as an agent of the employer, because it's the employer who could be giving drawings. The drawings are for his building. But when the PA is deciding how much time must be granted for extension, he is working as a semi-arbitrator. He is working as an independent person giving awards. This is why in this clause, in this slide, we see a bullet that says a PA's determination should be fair and impartial and uninfluenced by the fact that he is an agent of the employer. He issues this notice in terms of dispute clause in the building agreement. When PA responds to request to give written decision on the disagreement, PA is not required to act as an arbitrator. Yes, he's not going to hold the full sitting. He's not going to hold exchange of documents. He's not going to want to listen to a setup that's like in a court where one side presents its story and the other side presents its story. But despite all that, the PA's determination should be fair. It should be impartial, and it should be uninfluenced by the fact that he is an agent of the employer. When you find time, you must Google engineer as a quasi-arbitrator or principal agent as a quasi-arbitrator. Those of you who might end up in the line of life as quantity surveyors and principal agents, this is a very important aspect that you must appreciate. Your responsibilities will be at times to act fairly and in a manner that's open-minded, neutral, influenced only by facts and reasons. If it's been raining for 3 weeks, even though your client, who is the employer, has been telling you that I'm under the budgeted for this project, this mall should now be running 3 years already, and I'm out of funds. If facts on the table are that you must grant an extension of time, though you know it's got cost implications, and you've heard over coffee that there is a problem of money, you must grant extension of time. This is what this clause says. You must act fairly, impartially, and in a manner that is based on reasons. You cannot act in a manner that is capricious, that's unreasonable. This is a duty you must hold dearly from now on and for the rest of your lives. And when you are contractors and you can see that this principal agent is not acting fairly, you have to take steps, declare a dispute, take him to court. You must protect the interests of your organization as well. No one is into this thing for nothing else. Everyone is in it for money. And if you are on the side of a government department somewhere in your life, and there are good reasons to grant an extension of time, don't waste time. Don't give a people run around. Simply approve this thing based on reasons. But I'm not saying you must facilitate an assault on public funds here. Let's move to 22.12, mediation. If disagreement has been declared a dispute, parties may try to resolve by mediation. Mediator has to be agreed to and appointed within 15 days of dispute being declared. If there is no agreement, it's the same process that we discussed about. There is always an issue of whether the person is neutral and is perceived as neutral. Now, this is where a selection kicks in, and there is a need for that selection to reflect neutrality, because a perception of bias is as good as bias. Again, what we have on the slide is one version of JBCC, which is generally used for building works. When you come across civil engineering works or an interplay between building and civil, and the contract that is being used is GCC, don't stick on these notes. Look at what provisions of the GCC are saying with regards to this point, because it also has got its own bullets that are these clauses that are dealing exactly with the same thing. Equally, when you are in a large corporation that is using FIDIC, also don't hold to the 15 days. It's not 15 days on all contracts, but it's 15 days on JBCC. Look at what FIDIC is saying, and then don't hold this as if it's a biblical scripture. But for present purposes, our notes are on JBCC because this is what FinCEN is discussing. It's a tier trees on the JBCC. Let's move to the next slide, 22.13. I hope we are all still awake. Termination of mediation process. Mediator can terminate mediation proceedings at any time if there is little chance of persuading parties to reach agreement. Now, some of you might have worked before. Some of you might have had parents who have said they've got cases at CCMA. Basically, what you have at CCMA is an exactly identical procedure. When a person goes to CCMA crying foul, the first step they try to do at CCMA is to conciliate, which is more formal. Then when that fails, they mediate, which is semi-formal. When that fails, they issue a certificate that mediation has failed. Then they go for arbitration. When that is done, an arbitrator issues an award. When an arbitrator's award has been issued at CCMA, the Labor Relations Act has been drawn in a manner that is similar. Labor Relations Act, remember, is for 1995, but it has been drawn in a manner that is similar to the Arbitration Act of 1965, because equally, when somebody gets an award at CCMA after arbitration, they can take the award to the Labor Court, and the Labor Court can make the award an order of court. Then they can enforce it on the employer, because there can be cases where one is reinstated in terms of an arbitrator's award, but the employer ignores this. But when it's made an order of court at Labor Court, then it becomes more forceful, and more effective. Now, equally, the procedure which we are dealing with here is similar. Now, course of mediation, someone has got to mute. I think it must be Stole Viwe. Yes, thank you. Generally, cost of mediation is paid by both parties because mediation is not hostile. Parties would agree simply to share costs towards the mediator. In certain cases, when the state is involved, government might simply set up in these alternative dispute resolution mechanisms because it is in its interest, it's expeditious, and they may pay for people in their panel who will do the mediation, arbitration, and all of those things. Let's move to 22.15. Referring dispute on arbitration. Agreements allow parties who have been unable to decide on mediator, or if mediator has terminated mediation without all disputes being resolved, to submit unresolved disputes to arbitrator. In other words, you may have 10 problems that you are disagreeing about over a long period of time. And at mediation, you realize that, okay, we can compromise on 7. Then the remainder is 3. It is these 3 that have not been resolved that would still be in dispute that must be referred to arbitration. We've discussed the procedure of appointing an arbitrator, but the point that is being made here is that if one has been a mediator, definitely by then you have a very strong view that so and so is a problem in this contract. It is not advisable for the mediator who already holds strong views to now start acting as an arbitrator. This is all to underpin a fundamental requirement, the perception of independence and the perception of fairness. The minute you are not perceived to be independent, your decisions are not going to be respected. The minute you are not perceived to be fair, your decisions are not binding in the conscience of the other person. This is why we sometimes look and see judges discussing a judgment for 4 hours instead of simply saying, so and so you are guilty, go to jail for 10 years. They want to be understood in detail what they took into account and how they ultimately got into the final decision. So this is simply to underscore an important need, the requirement for fairness and a perception of fairness. Otherwise, this whole thing is not going to work when you are perceived to be in another person's pocket. You can't be taken seriously. Let's move to 22.17. Conduct of arbitration. We all know by now that arbitration is, in terms of the Arbitration Act of 1965, it gives guidelines. And the notes are telling us it must be conducted in accordance with the rules for the conduct of arbitration. Now, those rules are coming from our society, the Association of Arbitrators. Those are the rules that are being used currently in the country for the conduct of arbitration. You must be wondering in your mind now, what is this thing with Arbitration Act? And what is this thing with the rules? I want you to pay some attention here so that this does not confuse you. Our law is mainly based on 2 things: procedure and substantive law. Though murder is not permitted in our law. Still, even an accused person who is accused of murder is entitled to a procedure that is fair, is entitled to go to court, greet a magistrate, be told what the charges are, be given evidence against him so that he can prepare a defense, be assigned an attorney or a legal rep at the expense of the state, be told he has the right to remain silent. All these things are procedures. And if these procedures are missed, even a person who is as guilty as sin will walk free. Now, the Arbitration Act tells us most things that are substantive about how the arbitration must be held, the neutrality of the arbitrator, and all of those things. The rules for the conduct of arbitrations are simply to ensure a procedure that is fair, which allows for adequate notices, which allows for hearing in a date that is known by both people after adequate notice, and to ensure that there is no bias. So this is why you have rules, including at the High Court, because though there are a number of things that are discussed at High Court, the uniform rules of court are to govern a procedure for litigants so that no litigant wakes up in the morning, ambushes another, and there's a court date. This one now has to go to court unprepared because the notice is inadequate. The rules are to ensure fundamental principles of natural justice, which are old, founded in Rome, including by the time when Jesus Christ was hanged there. Rome was already a republic. This is why the law around the world is generally highly influenced by the Roman law. Now, already then, the Romans knew that there are rules of natural justice. There are fundamental principles of natural justice, which are simple. Give the other, okay, you are charged. You must know what the offense that you are being accused of. You are being taken to arbitration. You must know in good time what is it that is said you've not done right. You are taken to arbitration. Then you must have adequate notice to prepare your own answers to that. You must have a platform that is neutral and fair to hear your defense to the allegation. And the person hearing this thing has to be neutral. Now, the other components, whether you must pay for extension of time or you must not, that's more substantive. But for you to prepare your own defense to this finding that you must pay, you need to adequate notice. The rules are made to ensure these principles of natural justice are well respected, preserved, and upheld. Now, what we know, there are standard procedures, there are summary procedures. Both are available under the conduct of arbitration rules, and the summary procedures are generally used for less formal settings, in smaller contracts or where people are not really wanting to pay too much. But what is always emphasized is that the arbitrator must act judicially. What is this meaning of acting judicially? Let me make it simple. It simply means act fairly. It simply means, one, in essence, is to act in a manner that can be explained, that can be substantiated with reasons. You don't wake up, you say tomorrow, because you're an arbitrator, contractor is granted 8 months extension of time, and the employer must pay for that 8 months. That is not it. You are held to a higher standard. You've got to act in a manner that is not arbitrary, in a manner that is not capricious, in a manner that is well reasoned. This is, I have drawn an example. Sometimes people wonder, why is this judge going on for 4 hours instead of not telling us whether Zuma is going to jail or not this afternoon or this morning? He wants his reasons to be understood fully, because a well-reasoned decision is generally more respectable, more binding to the parties, including the losing one. A losing person wants to know, why did I lose? Sometimes then it's better. You can go to bed, you sleep nicely, and you know what to change in future in your life. Let's move on to the 22.18. Decision of arbitrator is given in writing in a document known as an award. Yes, this is what we've been speaking about. At CCMA, yes, they've got arbitration awards. In life, they also have arbitration awards whenever there is an arbitration. The Arbitration Act also talks of making an arbitration award an order of court. Now at the bottom, there seems to be a characterization which says awards are seldom made for specific performance. Let me explain what this means. In contracts, when one person is injured, or in other words, being disappointed by the other contracting party, the injured person has some remedies. One, it is to seek specific performance. It is to cancel. It is to sue for damages. What is specific performance? A specific performance is a directive which tells another person to perform particular steps. In other words, if you enter into a contract for delivery of maize to the harbor and you are a transporter, but you have not delivered maize, specific performance will direct you to deliver maize to the harbor within 10 days. Yet, whereas an award might be, because you did not deliver maize to the harbor, the cost of substituting your service is 25,000. Please pay 25,000. So here we are told arbitration awards are seldom made sounding in specific performance. So this is about it. I guess this is simply because of the practicalities of enforcement. Remember, we've spoken about an award being made an order of court. This does not say an award will never be couched in a manner that it makes it a specific performance. Let us move to 22.19. We are close to finishing our class. Soon I'll be taking questions. Cost of arbitration proceedings, enforcement of awards. Arbitrator will decide in his award who should pay costs of arbitration. Well, it is the standard procedure even in courts. The losing party must pay. We've discussed the enforcement of award. This can be done by making it an order of court. This is done with CCMA awards. This is done with general awards that are governed by the Arbitration Act. At CCMA, when an employee has an award, he takes it to the labor court for the labor court to make it an order of court. In life, besides in employment life, an arbitrator's award is taken to court to be made an order of court as well in any high court. 22.21, power of the court to remit or set aside the award. This is in cases of misconduct on the part of the arbitrator. We've been explaining throughout our class that there is a standard of behavior that's expected of an arbitrator. Then the next question is, what if the arbitrator has not acted in accordance with that standard? Is it inconsequential? Do you simply curse and go home? No. The consequences may be that the award itself may be cancelled by a court. This is what this is about. When a court sets it aside, it simply means it cancels it. It makes it not available. It nullifies it. These are all the things we don't want, because the whole point of taking matters to arbitration, remember, is part of what I refer to as alternative dispute resolution. An alternative to what? We don't want courts. Now, this is why we have to be held and to take the standards very, very seriously. you become an arbitrator or you're acting as a quasi-arbitrator, but you are seen to be compromised, the whole problem becomes the whole thing becomes a farce. What could be working beautifully gets compromised. It delays the delivery of construction projects. It delays the relief that is being sought by parties. Money is as good as it has come in good time. 10,000 today is 10,000 because of what it can buy. But when that 10,000 is given to you December next year, it is no longer 10,000. So once these awards are steamed and stalled by litigation, it becomes a big problem. This is where now a court, someone who's not happy with the award, this happens all the time, including at Labour Court, something comes from CCMA as an award, then someone else takes it to Labour Court. It's the same procedure, it's identical. And in construction, because this is governed by the Arbitration Act, Arbitration Act is not only governing construction, any agreement, including lease agreements and commercial leases. But what this is about, you are aggrieved with an award for good reason. They say there must be gross misconduct or it must be unreasonable. What is unreasonable is something that's not supported by reason. Those are the limited grounds for an attack to an arbitration award. Government departments generally are against arbitration. Thus would be indicated in schedule that disputes to be resolved by litigation. There is a big swing against this thing. Yes, it may be so, but there is generally a big swing against this thing. It's been introduced by the subcontract agreements that have been required by National Treasury. And government is collapsing under massive disputes under those subcontract agreements. In real life, I now know so many clients who have appointed arbitrators within their panels so that when there are disputes, they can quickly deal with disputes. Because government, remember, unlike us in life, we are assessed by how much money we save and how much money we accumulate. Government is assessed by how much money they spend. Now, if a hospital is stalled because subcontractors have not been paid, the senior people there at government are running a serious risk of even being fired for not spending the money that was budgeted for the hospital. So they are gradually realizing that arbitration is a quicker mechanism of solving the dispute so that the project can carry on, deliver services go to the people, and money expended to the project. So though it might have been so in the past, but by the time you are practicing, some of you who do already, you will realize that there is a general swing within the state and an uptake on arbitration as a dispute resolution mechanism. We are on 22.23 on our slides, 22.23. I want full attention on this one. I want full attention on this one. Some of you are going to be contractors in future. When you have referred a dispute, it does not mean you must stop work. Equally, some of you are going to be on the side of clients in future. When you have referred a dispute on payment certificate A, well, there can be no dispute on a payment certificate. There can be a dispute on payment of extension of terms and all of those other things. It does not say now, because you have a pending dispute, you must stop working on site. You will get into serious trouble. A contract can be terminated lawfully so because you have absconded from work. A contract can be lawfully terminated because you have now fallen behind your program of works. You are placed on terms. You don't bring an adjusted program because you are saying, I've got a dispute. You will get into trouble. The fact that you've referred a dispute either to mediation or arbitration or litigation during construction period does not excuse performance. You are not excused from performance. The GCC says so, the JPCC says so, and the practice in construction is like that. Imagine now, unless the dispute is around payment, then that's the only time work is allowed to be stopped. There it becomes very tricky. When the dispute is about non-payment of certified claims, remember we've discussed that the principal agent, quantity surveyor, civil engineer certifies due payment. When the payment has been certified, you work as a project engineer at Department of Health. You keep these payments in your desk, you don't sign them off. Yet the principal agent has signed. You are now a new graduate who is dealing with this project at the Department of Education or Department of Health. All your duty is give that payment certificate a cover letter. See what is the vote number that applies to it. Sign it off and take it to finance. Otherwise, you will cause havoc. The payment certificate that has been signed by an engineer is a liquid document. Don't try fiddle. That person has been appointed, has got professional indemnity insurances and other things that are already in favor of the state. If he's made a mistake, it's his problem. Don't try to second guess. We know the responsibility and power is not with you. All you need to do is sign paperwork, because in that case, a contractor is perfectly entitled to stop work and to hold the site under lien. And we've seen this being done in many government departments lately. Then a real dispute comes. This thing has been delayed for 3 months. The work that was done already starts now being destroyed by, platforms are already constructed, then there are rains, but the platforms are not covered yet, and these things go back. It becomes a massive problem. Generally, all other disputes, once they are referred to litigation or to a dispute resolution mechanism, be it mediation or arbitration, the contractor must still work. The employer must still pay payment certificates. This is the import of this clause, with exception of one thing. When payment is not being made, a contractor is entitled to stop paying. To stop working, particularly if a payment certificate has been issued by an engineer or by the principal agent. You are going to be interns in the government departments, and then you're going to be assigned projects to supervise. Careful when you are thinking of acting bigger than the engineer or the principal agent, who is much older than you are, more experienced than you are, simply because even his payments are facilitated by you. It doesn't say you've got more powers than he has when he has been assigned the project. We've discussed thoroughly the survival of dispute resolution clause. The clause makes it possible for the dispute resolution mechanisms to be in place, including after the termination of the agreement. I will emphasize the importance of that clause, just so that maybe I might use a different example. You were constructing a school that has got 4 blocks. 3 of the blocks are complete. The last block is incomplete. Now, you have issued certificates of completion for the 3 blocks. All these 4 are under one contract. Then the contract gets cancelled because the last and the 4th block is incomplete and the contractor is failing to finalize that block. Now remember, the contractor must still be liable for defects on the 3 blocks that he has completed, because he has been fully paid for those blocks. The defects liability period is as good as a guarantee, or what we know as a warranty. When you buy a car, you are told you've got a warranty for a year. If you were to cancel this whole thing, it means you are cancelling even the warranty itself. This is why mechanisms are embedded in the standard construction contracts to make it possible to have dispute resolution mechanisms, including after the contract is cancelled. This is so because it is known a construction contract does not end when the building is handed over. A contractor is still liable for defects, which may run up to a year or more. If now, on the 3 blocks where the contractor has been fully paid, completion certificate issued, he is on defects liability on those ones. Imagine there are leaks, and then he's not coming back to sort the leaks. With regards to those 3 contracts, you need this dispute resolution mechanism to be extant, to be in place, to be enforced, to be existing, so that you know how to address this other problem now. Thanks for your attention. We've come to the end of our class. I'm not sure if there are questions. If there are no questions, we are perfectly fine. If you think of questions later when you are engaging with your notes, you are more than welcome to drop to Ms. Songelo the questions. For those who can speak Xhosa whilst I'm still here, they may pose a question in Xhosa, but it's better if it's in English. Madolo, Kakambile, you are on the floor.
Good morning, sir.
Good morning, sir.
You're welcome. Morning to you too.
It's an eye-opener because we've faced, in some instances, we've faced disputes during in-service training.
Yes.
So what I just wanted to ask, like the one that happened where I used to do my training, was that there was a main contractor that had was involved in a joint venture. So there was a joint venture for constructing low-cost housing.
Yes.
So half of the party of the joint venture seemed to be failing to pay their workers. So there was a dispute between the half of the joint venture and their employees. So they ended up having almost like a demonstration and intimidation on site. So he wanted to sit over his portion of the contract to the company I worked for.
Yes.
So that happened, but I'm not sure about the legality of it, because we ended up taking over half of his work, and we completed the units for low-cost housing that we needed to do. But when it came to payment, we couldn't get paid. We ended up not getting paid, and then there was a dispute, which was there was liquidation of Tubelicha, who was, I think, the former HDA. Like it's HDA now, but it was Tubelicha at that point. So that ended up in court and ended up in Parliament also. But their argument was that they didn't have a contract with us. They had a contract with that contractor. Like, have you come across something like that in your work?
Yes. I guess you did not take cession of payments. I've heard you use the word seed. If you had taken cession of payments, the implication of that would have been that the company A is in JV with company B. Company B runs into financial problems. By agreement between company A and company B, they get into a cession agreement, which means company B is ceding all its rights and responsibilities to company A. Then the employer let's call employer C for now, can simply be notified that there has been a cessation of payment, and they don't have to be party to that agreement. And when that happens, they just must pay the money through the cession agreement to the company that has the cession in its favor. There are a number of similar cases. When you find time, you can Google starting with it's housing, it's nature. There is a company that generally finances low cost. I mean, it's not financing low cost. It's been financing construction works, particularly including mainly buildings. It's called Nature Housing Development Agency. You can Google Nature Development Agency versus Oudtshoorn Municipality. You will also see a long list of cases where nature has been involved, nature development finance, against a range of government departments. I'm trying to look at the Oudtshoorn one, but my spelling of Oudtshoorn is a bit tricky, but I'm getting into it now. Yes, it's Nature Finance Corporation versus Oudtshoorn Municipality. There is an SA decision there, but when you are done with that, you can see any other decision where nature has been involved. Nature has cession of payments. Nature uses cession to secure their money. And I've noted you, Yola, you're gonna be on the floor now. When nature